Call the first case on this morning's docket, case number 115377, State of Kansas v. Ontario Lowry.
Mr. Chief Justice, may it please the court, Richard Ney on behalf of the appellant in this case, Ontario Lowry. Mr. Chief Justice, I'd ask to reserve 3 minutes of my time for rebuttal.
3 minutes is granted.
Thank you. This case arises from the conviction of Mr. Lowry for the murder and attempted murder of a wife and husband in a drive-by shooting here in Topeka. 2 other individuals were also involved in the murder. 1 died before trial. The defendant here raises a myriad of errors that took place in the trial of this case. Let me try and reach a few of those. First, we would contend that the district court erred by permitting the defendant's statement into evidence. There was, in this case, as the record shows, an incomplete Miranda warning. The defendant was not advised that he could stop questioning at any time. That was never told to him. Further, no explicit waiver was obtained. Merely questioning started once the warnings that were given were given. We note this court's case, State versus Price, which is very much like this, that the incomplete warning that admits the right to stop questioning is incomplete and does not carry the weight necessary for Miranda or carry the advisement necessary for Miranda. Additionally, in this case, defendant's mental and physical health came into play. He had been in an accident, a car accident, following the shooting. He had complained about those injuries. He had struck his head. In fact, one of the officers testified he seemed, quote, out of it. During the entire interview, and going to the length of the interview, which was 7+ hours long, he yawned. He said he was tired repeatedly. He said he was tired. The interview started well after midnight in the early morning hours, and as I said, went 7 hours.
Well, you say 7 hours, that the interrogation was not a 7-hour interrogation.
It was not.
Yeah.
And I didn't
Just
mean
to clarify.
Yeah, I didn't mean to imply that,
Okay.
but he was in the interrogation room for 7+ hours. Again, complaining of his tiredness. It's interesting that the prosecution later used that to its advantage in closing argument. And I'll talk about the prosecutorial error in a moment. But said, oh, look at him, ladies and gentlemen of the jury. He's just so unconcerned with this. He's just yawning and, couldn't be bothered. He couldn't even pay attention. It was in the closing argument about his yawning. So rather than as an issue to suppress this statement, it was used as an issue against him.
What do you do about his response when, the officer says, did you sleep, or when did you last sleep, last night, how much? He said enough.
Right. But we're talking about last night being well more than 24 hours ago, or 24 hours ago. But after that, he repeatedly says, I'm tired. They say, yeah, I'm tired too, but we need to go on with this. 2 hours to the completion, before the completion, he says, I want a phone call and a pillow, saying how tired he is. And that brings another issue. He asked for a phone call, which was denied to him, relating to the issue of his ability to communicate with the outside world. Finally, the officers repeatedly in this interview said, here's what you're looking at. You can help yourself. You need to say something, get on board here. We recited that in our brief. Numerous times that was done. We would submit, Your Honors, that the statement here should have been suppressed by the district court. Secondly, the court conducted an ex parte hearing. And by ex parte, we mean that the defendant and his attorney were not present. The court's hearing was with potential witness, Ms. Jurgen Charles, who was being granted immunity. But it wasn't just about the immunity, because the court took up the defendant's motion in limine on Ms. Jurgen Charles at that hearing where defense counsel was not present and did not have a chance to argue. And the court made rulings at that time, significant factual statements about what might get in or what might not get in. The prosecutor even talked about how he was going to approach this.
And so your prejudice is because the motion in limine was granted in absentia, but your argument is it wasn't granted to the extent that you would have liked, and that may have happened if defendant had been present.
Well, let me give you an example.
Is that your argument?
That is my argument. And here's an example, Your Honor.
Gang names.
I'm sorry?
Gang names.
Gang names. Here's a quote from the court. Well, the prosecutor says, I want to get in names, nicknames, or whatever we're going to call those. The court says, well, I don't know what gang street name means. If somebody's got a nickname and known on the street a certain way, that doesn't necessarily mean that they are affiliated with a gang. So I don't know that that's a problem. Well, it is a problem, because those names that came out from Ms. Jurgen Charles later certainly sound like gang names, T. Black and some other things. But Mr. Conwell was not present to say, yes, it does make a difference, Your Honor. Let me explain it, since you clearly don't understand the import of it. And then it goes on, this is the same quote from the court, there's going to be any kind of implying that or inferring that the defendant has something to do with any threats made against the witness. Well, Ms. Jurgen Charles had testified in chambers without the defendant and counsel present that she hadn't been threatened by this defendant. But he didn't hear that. That's the problem. Then in closing argument, as we sort of segue into the prosecutorial error issue, the prosecutor argues that she felt threatened. So defense counsel had not been privy to the actual statements of Ms. Jurgen Charles on that. That was a clear detriment. And if you look at the case for the Court of Appeals, the Garza case, it's almost on all fours with this. Except, in that case, at least in one of the two hearings, defense counsel was present. This had prejudice to the defendant. And being told afterwards at a sidebar, oh yeah, we ruled on this, by the way, is not sufficient for him to understand and to hear that witness. On the issue of prosecutorial error, we cited numerous instances. We had the puzzle analogy being done yet again by the prosecution. And of course, this was after
in a little different form. This is a little different. The puzzles before, some of them, here's Mount Rushmore without one of the pictures. There's a lighthouse without a piece or two. Here, they were arguing that you get the outline of the picture when you shade in all around it, which is a little different kind of argument, isn't it?
Yes, worse, in my opinion. He talks about shading. Yeah. That's the word the prosecutor uses over and over. We don't have a picture here. You don't see a flower. You see the shading around what could be the flower. That's if there's the Mount Rushmore issue, again, I have problems with, but this is worse. The prosecutor is saying, we don't actually have any of the picture. We just have the shading around it so you can imagine what the picture is. And it goes on and on. More shading. Ms. Jurgen Charles, more shading. But then we have the prosecutor with the Carrolls, David and Leanne Carroll, talking about how they were threatened and felt threatened. He asked, although there were no objections to David Carroll's testimony, I don't know why, but repeated objections were made to Leanne Carroll's, where she's asking, who are these guys? Did you feel threatened? We got talk about them being homeboys. It just went on and on and on, despite the defendant's motion in limine on this. This was not just a question that improper things came up. They came up in violation of the motion in limine on gang evidence. So in both of those cases, in closing argument, the issues of error went on and on.
But before you get
Yes.
there, you do agree that you have to deal with King with respect to the husband's testimony. You just mentioned you don't know why there weren't objections, but there were, and there really hasn't been given any, or recent cases don't give any wiggle room for you to get around that, do they?
Well, let me try and wiggle a little bit, Your Honor. When you file a motion in limine, I think that has to have some bearing, and the court has already ruled, don't do this, and if the prosecutor does it, I think that's different, at least fundamentally so. Why do I need to file a motion in limine?
You're preaching to the choir, but I don't
Yeah.
think, we've said that it doesn't matter if you get a ruling or you get 12 rulings before trial, you gotta make the objection at trial.
I understand that, Your Honor. And maybe that's why the defense attorney thought things had been dealt with. During closing argument, as I said, the prosecutor says these statements about the Carrolls were threatened. Ms. Jurgen Charles was threatened. Again, here's his, as far as the Carrolls are concerned, here's the closing. A friend of Mr. Lowry's goes over there, and as Mr. Carroll said, it was a very intimidating situation. Well, really, he didn't say that. More shading. Why would they want that? Because they don't want him testifying, because they don't know exactly what he saw. They want him silenced. There was nothing about that in the record. It's about these people go over, they have a fight with each other, a man and a woman, and there may be some connection to the defendant. Maybe. These are leaps beyond leaps. The prosecutor argues that Melvin Ray is not hiding anything. He's given it all to you, the good, the bad, the otherwise, because he didn't do anything wrong.
Counsel,
Yeah.
before we run out, let's move over to the strength of the prosecution's case, because if we get past the prosecutorial error, then they're going to be in constitutional error land. The one, regardless of how we characterize the state's case, the one piece of evidence that's giving me some trouble is the latex glove with the partial DNA that could not exclude the defendant. I think it was a 1 in 4. I mean, it was a partial DNA thing, but it did exclude the other two people, Brown
Right.
and the other.
Right, and
Everything else being what it is, why is that not pretty good evidence for the state on that latex glove?
Well, evidence that at some point he touched that glove, it's 1 in 2. So, four of us would have the same DNA as that glove. That's why it's bad. I mean, what does that tell us? If you're down to, if you have 8 people here, and one of us could have been the person who touched or 4 of us could have been the people who touched the glove by statistically, how does that help the case?
Well, then it just ties back to the other evidence, but it's more concrete. In my mind, it's bothering me that isn't more concrete than maybe the other stuff, and so
Right.
that's what's causing me trouble. So I'm just giving you a chance to talk about it.
Well, and that's what I can say. But let's look at how the prosecutor used the DNA evidence on the gun. Mm-hmm. What it was said was that was 1 in 4, the gun. And the prosecutor said, well, it wasn't really 1 in 4. It's got to be his because there's only 3 people in this car and 2 people are excluded. Well, that's not true. Obviously, again, the 8 of us, 2 of us could have left that DNA statistically. It didn't have to be anybody that had been in the car. Just because you can exclude Mr. Brown and Mr. Robbins doesn't mean it has to be the defendant. It's 1 in 4. But that's exactly how it was argued. It took the population arguments in DNA and stood them on their head.
Well, that presumed that one of the occupants had to be the one that touched it.
Change it from a possible.
Yeah, it presumes it. But remember, this is not a gun who fired any of the rounds. It's just a gun.
A jammed gun.
A jammed gun that couldn't fire, and so it was not the gun used in the shooting, clearly. And then we have, of course, the fucking idiot remark by the prosecutor. Now, there was an issue about, did he say to the defense attorney, he's a fucking idiot, or does he think I'm a fucking idiot? But there's no difference in the sense that he's saying those words in a courtroom where a spectator in the back of the courtroom could hear. That's troubling. And certainly if we were pre-Sherman, we would say that's an indication of
The
bias.
thing that bothers me about that particular sub-issue, the improper gestures and comments section, is I can't imagine if this were happening, why there wasn't let's approach the bench. And Your Honor, I would ask that you keep an eye out on what the prosecutor's doing, and I'd like for you to control your courtroom so we don't have this. And there was none of that, and so it would have potentially dealt with it. And that's why we asked for objections, is because if you can snip it in the bud, then we don't have to spend time on a appeal to the Supreme Court to talk about it, because it's taken care of.
I agree, Your Honor, but here's a problem. I can tell you as a trial attorney, I've been in situations where I'm talking to the court, I'm pressing a witness, don't have eyes on the prosecutor.
But this wasn't just a witness in the back of the courtroom, it was defense counsel's wife.
Right.
Yeah.
I understand.
Yeah.
And I don't have an explanation for that, either why it was not done.
But you understand the problem there is there are times when the need for an objection is manifestly evident.
Well, and you're aware that the judge could have observed some of this and taken some action too. And not to embarrass you, Mr. Ney, but I recall a case that was recently argued in which the judge confronted you about some behavior and facial gestures during the trial, and she took action to admonish you, or at least in her impressions, experienced that. That didn't occur here either.
No, it didn't.
And you would think that perhaps the court would have observed some of at least the hand gestures and the shrugging and the things like that would be beyond the bounds that you're arguing.
Right. But I mean, if we look at the record here, those things were not really denied, and the words fucking idiot were admitted by the prosecutor and the assistant prosecutor. So, I mean, is it okay to say those words in a courtroom with potential jurors and other people hearing? Or jurors and other people hearing that potentially. I see I'm out of time. I would just also add that we believe that the Overstreet issue is critical here. That instruction could not have been more damaging. This is the case where premeditation was certainly an issue. Any time there's a drive-by shooting, if you will, who's driving, who's shooting, who knows what's going on. There's 3 people in the car. At least one person was not doing either the shooting or the driving, presumably. And that instruction certainly destroyed the requirement that the state prove presumption beyond a reason, the premeditation beyond a reasonable doubt.
Is this the instruction that was in the proposed instruction from the defense?
It was.
Okay, doesn't that give you an invited error problem?
We've looked, and I think we argued that in our brief. I don't see invited error, or in our reply at least, as an issue that is in jury instructions. Obviously, we're in the realm that the defense attorney didn't object. I don't think the standard, at least from what I can tell, is any different from not objecting to actually offering it to the court.
Well, I think we have some cases that do distinguish that the difference between standing silent when it's proffered by the prosecution or the court versus being in your own packet that you proposed and you get what you asked for. I mean, that's kind of what invited error is. If you get what you asked for, then you can't later complain.
In our position would be if a jury instruction is clearly erroneous, it's clearly erroneous. And there's not sort of clearly erroneous if you ask for it. Obviously not a great idea, but The law was clear at that time that this was an erroneous instruction.
Any further questions? Thank you, counsel.
May it please the court, Rachel Pickering, Assistant Solicitor General. There were several issues raised in the defense's brief. I'd like to go through issue 1 and 2, and if time allows, answer your other questions. With respect to the first issue on prosecutorial error, the Richmond rears its ugly head for the defense, but not for the state, in arguing that the issues relating to his argument that the prosecutor repeatedly violated the motion in limine, the state argues that that has not been properly preserved. The contemporaneous objection was not made at district court, and therefore the point, as Justice Johnson mentioned earlier, the point of an objection at district court is for the allowed court to correct the error. And here, if the court does not know about the error, as argued by the defense,
But the court didn't correct the error with regard to Mrs. Carroll. There were objections in,
Yes, but not with respect to the motion in limine.
it was a different objection.
It was a different objection. And this court held in Richmond, you can't object for one reason at district court and then come up on appeal and argue a different reason. So the state's argument is for that first part of the prosecutorial error argument that was not properly before this court. And even so, we argue that those are not violations. The second gets to the use of a puzzle analogy. And Crawford, a review of Crawford is where this court said in 2014, we really shouldn't use a puzzle analogy with respect to reasonable doubt. But there's a key difference here. A prosecutor should be able to use the word puzzle when they're putting together the evidence, because that's what the prosecutor used here properly. Unlike in Crawford, the prosecutor was referring to missing pieces of a puzzle, and that's very clear, and it's not in our brief, but I'd like to bring that to this court's attention. Missing puzzle pieces, and whether jurors were left with the reasonable question. So he was asking the jurors to fill in those missing pieces. And we also see that with the picture of George Washington. It's another case where it's not all there, but you can kind of fill in that it is George Washington. Here at closing, the prosecutor tells the jury the importance of all the evidence that is here. If I could get to that site, Your Honors. I believe it's in our brief. Each piece is then put together, is then put aside. The next witness brings their piece, and eventually all the pieces come together. So this is completely opposite of Crawford. In Crawford, the prosecutor is saying, fill it in. Here he's saying, no, wait, there's a reason for the evidence here. We put it all together, and that explains it.
That might be true, but then he goes on and he's arguably, at least, well, this is defendant's argument. He goes on to say the picture might have a missing piece, and you know what it is.
Well, the thing is, he also does talk about the importance of all the besides all the pieces of coming together. He talks about how this is a crime that's committed in the cover of darkness in the absence of witnesses, and so the pieces are all coming together.
I guess I'm just asking, you're trying to distinguish this from Crawford by
Right.
saying in Crawford the problem was you're missing a piece.
Right.
And I'm asking you, why isn't the argument, I don't have to draw the flower because I've drawn everything around it? I mean, isn't that exactly the same? It's saying, here's a picture with a missing piece,
Well,
and
the-
you can infer what's missing by what's there.
Well,
That's
the-
the entire argument he's making.
Well, the argument that and it's in our brief, is that in Crawford they were really talking about reasonable doubt, and he talked
Okay,
about
so that's a different distinction.
yes,
Are you going to rely more on the fact that the problem with Crawford was that it occurred in the reasonable doubt context?
correct,
Well,
absolutely,
explain-
because
explain to
not
me
every.
What,
I'm sorry.
Why are you using this analogy if you're not trying to explain that the state's met its burden
Well, the state has met its burden.
and you're talking about beyond a reasonable doubt? How is that different? I don't get the distinction here, using this analogy here as what was used in the other cases that we disapproved.
Well, because in his closing, he doesn't lessen the burden of reasonable doubt. If you read through his close in the entirety, he doesn't do that. And so he may discuss shading, but it's not used in the context that it's used in other cases. With respect to the statement that the prosecutor makes to another prosecutor, if this court has any questions, we've already argued that he did acknowledge that he said that to another prosecutor, and that there was no evidence presented that the jury had heard that. With respect to closing arguments on the forensics issue that the defense raised, it's very important that in discussing the DNA that the prosecutor does explain to the jury in going through the DNA evidence. In the beginning, he says, "And if I say anything during this portion that you don't recall or you do not believe is accurate, as the judge told you, disregard it." So already he's telling them, if I misstate something, disregard it.
Are you talking about the DNA on the, well, I mean, it was just fundamentally wrong.
Well, he says on the gun, he
It's a
said,
matter of probability it's wrong.
Just a misunderstanding of how probability works.
Right.
Converted probability to a certainty.
well, we would argue that he was allowed that inference. I think that's the argument.
Well, no, that's the
No,
point.
it's scientifically unsound completely. It's mathematically unsound.
Exactly.
Not scientifically, but mathematically unsound. So that was a mistake. So tell us why it doesn't matter.
It's the mistake because
On the DNA evidence, the way that he described it to the jury, well, it's 1 in 4, so that means blah, blah, blah. You know,
Well, this
that
is
was
what
just
he-
wrong.
well, can I just go through what he does say?
Sure.
And there's DNA on it, right? And whose DNA is on it? The defendant's. Not that it's one of those high numbers, not 1 in 6 quillion. It's one of those low numbers. And I don't know if it's 1 in 4, 1 in 8, or 1 in 12. It's in the evidence. I think the 1 in 12, but I don't want to misstate anything. 1 in 12, that could be one of you, but that's not how it works. It's compared to the rest of the world's population. And so his point was, you have 1 in 12, but the other 2 people are eliminated. The other 2 people in the car are eliminated. And so his point is, the probability is on the defendant. This is page 21.
I think
99. Am I
that's
referring-
not the statement that was complained about. I think is where he said there's 1 and 2, and it wasn't the other 2, and so it had to be your client.
Right.
And that means if the probability is 50%, 1 out of 2, it doesn't matter if there's 20 people in the car or no one else in the car, the probability remains the same. Just like if you rolled dice 20 times and they're all 7, it's still the next roll is still 6 out of 36. I mean, the probability is the probability. It's independent probability. It's not dependent upon
Who else
how
is
many
sitting there?
people are there.
In other words, it's not a reasonable inference to be drawn from the
Drawn.
evidence.
Okay.
So if you just assume that, why is that harmless error?
Well, it's harmless, certainly, because the evidence against the defendant is strong. Even if you don't take a look at the DNA on the gun, you have him running from the car where a gun is found. You have latex gloves, which shows premeditation. You have a car tracking another car the hours of 1:34 in the morning downtown in Kansas. on Kansas Avenue. You have the defendant in the same location where the wedding is taking place over 12 hours earlier. You have the defendant in the same location an hour before they leave the one building. You take all that and minus the evidence of DNA on his gun and on the gun found in the car where the defendant runs from and acknowledges that he was in and driving, and there certainly is sufficient evidence. So our argument would be that the harmlessness error is met.
Tell me why it's not error to consider a defense motion and rule on it without defendant or defense counsel present.
This case is nothing like Garza.
No, I mean, as any motion filed by the defendant, why isn't both the defendant and the defendant's attorney required to be present when the court considers that
Well,
and considers evidence with regard to that and makes a ruling on that motion?
well, in this case, the ruling was favorable to the defendant.
Not 100%. Not 100% favorable, right? Because the gang names, the judge said, no, that's okay.
Right,
Names
but-
are okay.
Right, but let's look at the impact of those gang names is the word rabbit. My
Well,
sister calls him.
Let's don't go down that rabbit hole
Okay.
right now. I want to back up. That argument would be why the error was harmless. If they
Right.
won anyway, then it would be harmless error, but that doesn't mean it's not error. The defendant had a right to be present at his own motion and be represented by counsel at the hearing on that motion. Do you agree?
I agree
And
that,
so it's error. And what you're arguing now is it was harmless error because he won anyway. But that doesn't make it okay. That doesn't make it constitutionally sound that you've excluded someone from a critical stage of the proceedings. But that would be your harmless error argument.
yes, but we also have to note that when that took place, the defendant and the defense attorney were in the courtroom within minutes later, and the judge told the defense attorney what had happened, that she had granted his motion. So it's not like this is a hearing and then, 2 weeks later, we now are ruling on it. It's really, we really need to take a look closely at this
So you can
record.
exclude them if you tell them what happened real quick afterwards.
No, I'm not saying that.
Well,
I'm just saying.
what are you saying? Why
I-
isn't it error? Why isn't it error?
If a defendant files a motion, he should be there for the court to rule on it.
Thank you.
We would argue that that motion was very favorable to the defendant. The judge even says that. And Judge, Your Honor, I do want to say something. The judge says in the beginning, defense counsel should be here. And then she says in the beginning, she does say, we are here to protect his rights. So we have but I do want to tell you that there's some earnestness of behind that all. Now, how was it? It was actually very helpful. This person who came in and testified, the defense counsel, and it should be noted, it's not in her brief, defense counsel never asked this witness any questions. So she came in and testified to what? Not about the defendant's actions, but about the other two people in the car. How they came to her house, knocking on the door, needed a phone, and they were wet. That's what she testified to. And as outlined in our brief, that evidence would have been brought in anyway through other witnesses. There is, I've already gone through the sufficiency argument with respect to the facts here. And I believe that's really a strong reason why this court should affirm Mr. Lowry's, all of his convictions. There's no further questions.
You want to address the argument on the involuntary nature of confession claim, specifically with regard to the validity of the Miranda waiver?
Yes, something noted is that the defendant had been read his Miranda by Detective Dickey. And then when he was read it, do you have any questions? He says no. And it is also noted that the defendant has been read Miranda in the past before. So that's important.
But it's your contention that what was read was all that had to be read.
Correct. Correct. And this court, it's not cited, but as this court is very well aware, and other case law has said if the defendant wants to stop that interrogation, he should say so. And as noted, although the defense did say it was 7 hours, it actually stopped less than that. And the district court did find the defendant responsive at the Jackson v. Deno hearing.
Any further presentation?
No, Your Honor.
Do we have any more questions? What are you asking the court to do?
We are asking this court to affirm his convictions.
Very well. Thank you,
Thank you.
counsel.
May it please the court. Turning to the DNA evidence, the statement the prosecutor gave was, quote, "The population is down to 1. And population, in the terms of DNA, has specific meaning, which means the population of the possible persons. And that's just a misstatement of the evidence. Regarding the shading, again, why we think this is worse. Here's the prosecutor's argument when he introduces this concept. What we're trying to do here is kind of paint a picture of what happened May 25th. Some of the witnesses were there, some of them weren't. So how do I paint a picture to you of what happened those early morning hours? Well, in presenting a case in a criminal trial, oftentimes we don't put in evidence and exhibits, and it shows you the picture. We're not drawing a picture. What we really do is shade the area around the picture. So when we get done shading, what is revealed to you is the picture of what's left. Like a flower. Instead of me drawing a flower.
Counsel, why isn't
Yeah.
that just a rather lengthy explanation of what circumstantial evidence is? In other words, why isn't that just the prosecutor saying, look, you can draw reasonable inferences from the evidence?
Because it goes on to say, you will look at it and you will say, that's a flower, yet I've never drawn a flower.
Right, that's about drawing inferences.
That's like, here's Mount Rushmore, but I never drew President
there's
Roosevelt and President Washington.
One distinction, possible distinction, between those earlier cases and this one is, and our case law talks about this, that the earlier cases invite the jury to think about the case as analogous to something familiar to them, something that they already know what it looks like.
Like a flower. I know what a flower looks like. They probably do too.
Yes, but it's not a specific flower. It's not, the sunflower on the Kansas state flag or something. The point being, what's the difference between these two things? I can kind of see it both ways. It seems like it's just saying you can draw reasonable inferences. And the fact is, if I eliminate every other possibility but one, it's a reasonable inference to draw that one is the one.
That's what he could have said.
Right, and why isn't this, I guess I'm asking, why isn't this exactly
This is
that?
saying you can determine what's here, even though you don't see it, even though I haven't presented it. And I think that's worse than saying I presented part of the picture and you can fill in the rest.
But what you're saying is if he would have used the shading and says, I'm not gonna show defendant driving the car or shooting the gun or whatever, but when I shade it in, you'll see that what you're seeing.
Right.
The defendant committing the crime. You're saying when you use the flower, it's a familiarity problem that we've had with Mount Rushmore or the.
I do too. If we change it slightly, it says, oh, well, I drew a stem, but I didn't draw the rest of it, you can tell it's a flower. Well, I think that's as bad as this or this is worse. One other point I'd like to make. The prosecution said here that Ms. Jurgen Charles, well, it didn't go into it, all these things. Well, the reason Ms. Jurgen Charles was called is then the prosecutor called the police officer who interviewed her and he could only call the police officer if she testified, and then put in all that damaging material through the police officer. So I think that's a little disingenuous that didn't come in through Ms. Juergen Charles. It did by bringing the police officer in. And I would note that part of the colloquy that goes on, that I believe is still in chambers, is, are you going to call the officers? He says, I don't know yet. And that defense counsel didn't hear either. There are no other questions.
Any more questions of counsel? Thank you, counsel.
Thank you, Your Honor. I would ask that the court reverse this conviction.
Very well. I thank you both for your arguments this morning. Court will take this matter under advisement.